Good evening, this is Robin Thompson, and I hope you enjoy this presentation on the famous and historical Marbury v. Madison court case. Marbury v. Madison is arguably the most important case in Supreme Court history. It was the first United States Supreme Court case to apply the principle of judicial review, which means that the power of the federal courts to void acts of Congress that are in conflict with the Constitution. And in the election of 1800, the newly organized Democratic and Republican Party of Thomas Jefferson had just defeated the Federalist Party of John Adams. So in the final days of John Adams' presidency, he appointed a large number of justices of peace, one of those being William Marbury. Now, these commissions were approved by the Senate, they were signed by the President, and affixed with the seal of the government. But the commissions were not delivered. One of the duties of President of appointments is you have to be active at the time that you proceed with the appointment of the justices of peace. And unfortunately for John Adams, his appointments were not completed in time. They were not done in time. And when Thomas Jefferson came into office, he told his Secretary of State, James Madison, to reject Marbury's appointments and refuse to finalize the commission process. So, unfortunately, John Adams' presidency ended before he was able to formally appoint Marbury. So, frustrated and upset that his appointment was suspended, Mr. Marbury brought this case before the Supreme Court. And the Supreme Court announced for the first time that a court may declare an act of Congress void if it is inconsistent with the Constitution. And in this case, William Marbury had been appointed a justice of the peace in the final hours of an administration, but because it wasn't done in time, it was rejected. So Marbury joined some other appointees in a similar situation as his, and they petitioned for a writ of mandamus compelling the delivery of these commissions. So Chief Justice John Marshall denied the petition and refused to issue the writ. He found that the petitioners were entitled to their commissions, but he held that the Constitution did not give the Supreme Court the power to issue writs of mandamus. He stated Section 13 of the Judiciary Act of 1789 provided that such writs might be issued, but that section of the act was inconsistent with the Constitution and therefore invalid. So it spelled out the practice of delivering commissions for judges and justices of the peace, that it was unconstitutional because the Supreme Court had authority that was denied by Article 3 of the Constitution. So basically, the